have with us today retired corporate attorney Maureen Martowska. Maureen's affectionately referred to as Grandma M. She holds
Thank you. And I want to thank all the representatives who are listening, who have allowed this panel to convene and to speak about what we think would be good solutions to the problems that we're seeing in the Connecticut Family Court. I want to thank in particular the people who came out today to listen, to become educated, to the judiciary who are listening and who are hopefully, and I'm sure want to become educated as well. And most of all, I hope that we're all here for the children, because ultimately that's why we all are in family court here. And as a matter of disclosure, I do have a son who has an active case here. And I am very much concerned about the Connecticut Family Courts and the ability to make positive and timely and efficient changes. Mark Sargent had indicated and highlighted a number of the issues and concerns of other legal professionals. Unfortunately, we have a certain number of people who are willing to speak out on this issue. I'm a retired corporate attorney, and most of all, I'm a grandma. And I have one connection probably with every single person here, and that is that you likely have a child, and if you don't have a child, you have a cousin, or you have an uncle, an aunt, a grandma, a mom, a dad, somebody in your life who means something to you, who your life centers around, that nothing is more important than your family and your children. And when that is interfered with, and when your rights for care, custody, and control of your children is interfered with, there is nothing that parents will not speak out to in regards to that. And I also want to address the issue of disgruntled parents. I think that is such a misnomer, and it shows a great deal of respect in an atmosphere where we need to respect and have civil discourse between lawyers, judges, behavioral health people, and parents, and to all join forces together for the children. Questions came up. What are the possible solutions we can do to fix some of these problems? So I decided to myself, I'm going to start with the solutions, and I'm going to tell you why the solutions are needed. The first question on any judge's folder that comes before them is this: how long has it been since that child has seen either parent? That's the number one question. And it's a clear indicator to the court if he's seeing that there, or she's seeing that there are cases out there for 10, 12, 5 years. It means there's a loss of control of the case. And so I would recommend, number one, that the first question on any file be to find that out. The second thing I would ask, and I would say this is a pretty important consideration to think of as a possible solution, and that would be a presumption under the law for shared parenting. I think if parents were given the due consideration and respect that and the constitutional rights they have, that would be a starting point of discussion here. I think that eliminates putting parents in an adversarial position against each other and leveraging tools that creates further avenue for people to dig in and become ingrained in their positions. The third thing I would suggest to you is to find a way to treat false allegations in a very serious manner. They undermine family court cases. They undermine domestic violence cases. They undermine parental alienation cases. They need to be given the gravity that they deserve. And that means very serious consideration about severe pains and penalties, things like jail time, court costs, modifying custody, fines. And there has to be a willingness of the court to enforce those. One of the other things I'm going to say is that honoring prior orders and enforcing them is very much, in my mind, I came, into the family court system on the basis of my adult son's case. And what I was able to observe, and attorney sergeants observe the same thing. You come in with a unique perspective as a parent, but even more so when you're educated in the law and what you expect as far as how prior orders have been handled. And I'm going to give you one example drawing upon my own personal experience, where my son has a case where we went into court, and he's on SSDI, he's indigent. The other parent is on a minimal income as an elementary school teacher. The parties are taxed greatly financially because they do have to support children. The problem is that you have an evidentiary hearing usually on these financial matters. It's an evidentiary hearing where people bring in their witnesses, make their testimony, they're cross-examined by the judge actually asks questions, responses are given under oath, financial affidavits are looked at, and usually what typically happens is there is a form called the worksheet, and it's on for the Commission on Child Support Guidelines. It's a form familiar to most attorneys, Form CCSG-1. And typically that's used by the judge to determine where are we as far as the financial status of the parties and how can we determine the appropriate apportionment of fees. In our particular case, it came down to a 30-70 split, 30 on my son's side and 70 on the mother's. So we have a court order that issues, and it's there for the fees, how it's going to play out going forward with reunification specialists and individual therapists. Fast forward 12 weeks, nothing's happened in the case, and then there's been no substantial change of circumstances. In fact, there's been none. Another judge comes in, a different judge, and now orders that the financial split, in her view, for whatever reason, should have been a 50-50 split. So we have an order now without another evidentiary hearing and without any ability to, at that time, have the evidentiary hearing, without asking for another pause here to do that. An order is issued to do that, to change what a previous court order had done. So the undermining of, and it's no wonder that parents have experienced this, and it undermines the credibility of the court. So it's one thing that we have to do is honor prior orders and enforce them. The fifth thing, and this is very important, and it should be high on everyone's list. When we talk about the confidentiality of medical records, there should be nothing more important than the children's confidentiality. And it has come to our attention that on many occasions, when a memorandum of decision is issued by the judge, we have seen children's information in that. It's in perpetuity on the website when these court decisions are issued. And those children suffer because eventually, as these children age out, or depending on their age, their peers see that. They get bullied in school. They go through depression, and there have been attempted suicides. This has to change, and this has to immediately be addressed. It's important to protect the children. It's in their best interest. The next thing I would say is that if parents have arrived at a signed mutual stipulated agreement, they present to the court that agreement, if it's made knowingly, willfully, intentionally, and voluntarily, should be honored by the court. There are cases where we've seen parents come to the court and for whatever reason the judge may not like it, may not think it's in the child's best interest, and asserts their best judgment over the parents who have mutually come to that decision and have rewritten the agreement. We think that's very important, that parents be respected, and if they mutually come to an agreement, that it be honored. And I also want to suggest that we, as I said, have this very civil and very courteous dialogue, regardless of our points of view. And one of which, and I'm going to begin with this phrase, disgruntled parents. I think it's a label to stigmatize and marginalize people's concern. It's also an attempt to shift the blame from where the true issues are. There's a difference between not being happy with the results and not being happy with the process. Because if people and parents had confidence in the process, then I believe that no matter what the result, there will be surely some people who may not be, but for the majority of people, if they felt they were dealt with fairly and according to the rules of procedure, the rules of evidence, that there would be much more respect and there wouldn't be this disgruntled label that you're assigning to us. And so I would also offer another solution. One would be that courts need to operate more efficiently, and they need to be cognitive of the litigants' time and money, time that they take away from work, time that they have to pay babysitters, and understand truly the hardships that these parents come with, especially when we're talking about status conferences that are scheduled pretty routinely with these more complex cases. It costs money. I also want to bring up the issue of ADA accommodations. Typically, if a person requests ADA accommodations, and many people who have disabilities may not be aware that they have that ability, that there are ADA accommodations available to them, they initially would file that at the family court level. Some people go on to the appellate court, and they're told that they have to additionally file that. And that is not the case. They do not have to do that. And this should not be, for people especially with cognitive deficiencies, memory issues, executive functioning issues, this is another barrier to them. And ADA accommodations have to be something that starts to be paid attention to by the courts. That would be one of my other suggestions. One of the other things that comes to mind is that we have an issue, as Mark had raised, about ongoing costs and burdens put onto these families. And I don't think, unless people have walked in these shoes, how difficult it has been for these families, because nobody knows how many families we've lost along the way. But surely we do know from personal experience, both Mark and I and others that we've spoken to, that when you have financial resources, there seems to be a target on your back, because that's where the money is. The money is there for the GALs, who may charge $350. The money's there for the attorneys. The money's there for the attorneys for the GALs, as Mark had just indicated to you. The money is there for the therapists that the families have to pay for. And by the way, a lot of these therapists are not covered under insurance as a result of them being considered forensic in nature versus therapeutic. So they also have to absorb those costs. There may be supervised visitation, psych evals at $10,000 plus. And we're talking multiple psych evals, likely if you dare have a mental illness. Mental illness, 1 in 5 people have it's been estimated, and this is through the sources of National Alliance of Mental Illness, have a mental illness. This is very disheartening, because knowing that the Rocking the Cradle study from the National Institutes of Disability had actually done the research on this and had given the statistics that upwards of 80% lose access to their children, is really something that we need to look at, that they do not receive disparate treatment because of this disability. One of the other things I would ask that you look at is that the court stop acting as a collector of outstanding debts to court vendors. That when parents are unable to pay these exorbitant fees because of all the burdens laid upon them, that it's understandable that people have mortgages, they have college educations of maybe other people in their family, that there has to be some weighing of a family's true life, real life experience. You know, it sort of reminds me when I list all these different things that come upon parents, I think about those who don't come from any financial means and where they just cannot even afford it emotionally or financially to fight this. And they have to unfortunately walk out the door. How sad that is. How sad it is. Because whether you have money or you have no money, one way or another, the child loses. And I'd like to say, you know, when I think about the costs, that like that hearing aid commercial that many of you have heard, you see the father with the son, you know, how much do hearing aids cost? $2,000, $5,000. And then he ends up saying, whatever the market will bear. And that is something that I think is very true, which the expenses we see with being put on these parents. The indigent quickly discover that they can't afford court vendors and either give up because of lack of finances or emotionally cannot handle it. I want to also talk about state rate GALs. That might be a possible thing if a GAL is needed. Frankly, I do not feel GALs need to be used as often as they are. I think that they should be used sparingly and for limited duration. And there is a thing called a sliding scale now given to GALs. But it's interesting to note in Fairfield County where the cost of living is tremendous down there, and typically the income levels are higher than you would see around, let's say, Hartford or Putnam or someplace like that. You'll note that the state rate, that is the sliding scale for these GALs, it's capped off at, there's a sliding scale that's capped off. Typically, I think it was at, depending on what your income was, it could be where you're paying $100 an hour, or if you were at $50,000, and it goes up from there. The issue there is that in Fairfield County, you're not going to be, a lot of people aren't going to qualify for these sliding fee scales. And instead what's going to happen is you're going to see attorneys appointed for GALs at $800, $850 an hour, and that creates a big problem nonetheless. I would also say that there needs to be, parents need to be advised when they go into family court. One of the solutions. When they go into family courts, there needs to be an agreement whenever a child, or a parent rather, his order as far as access to his child is changed, and let's say substituted by another stipulated agreement. A lot of parents are under the misconception that any prior order that gave them a certain degree of access is not overridden. It can be, and whenever it is, notice should be given to the parent, because there's been many cases where lawyers have not explained that to their client. And I would ask one other thing, that when we draft any legislation, that we start substituting the term parenting time instead of visitation time or schedule. Parents are parents. They're not visitors in their child's lives. They may feel like that, but they're not. I would also ask that supervised visitation. You know, we've heard past testimony when we had a task force back in 2014. Supervised visitation was said to be used minimally, and it's never really more than a couple months. Supervised visitation does take place, and it has occurred for a year, 2 years, and in our particular case, it took place as a result of nothing more than giving the mother comfort, feeling that she was comfortable. I don't think that's an appropriate use of supervised visitation. Most importantly, we need leadership, we need oversight, and we need accountability of the judiciary. We need to have that to restore the confidence. It's lost among the parents. So I would ask that you consider all of these suggestions and use them as best as you can when you consider new bills that are coming up before being proposed. A bunch of them are for parental alienation. And that's a very complex issue, and I hope the experts that come up, you'll listen to them, you'll come to become educated on it and see why that needs to be highlighted and really paid attention to. And I thank you for listening.